Well, everybody, this is one of two documents that was filed today, June 8th, 2022. Defendant Netflix Incorporated supplemental brief in support of the motion to compel production of documents responsive to subpoena to Michael Griesbach. As a request of the court, Defendant Netflix Incorporated respectively submits this supplemental brief regarding the Wisconsin reporter privilege in support of the motion for order directing Mr. Griesbach to produce documents responsive to the third-party subpoena. The subpoena. Introduction. The circumstances surrounding Netflix's motion to compel the production of documents by Michael Griesbach are unusual. As the parties, Mr. Griesbach and the court all acknowledge that it is unusual for a party's legal counsel to also be a fact witness in the matter based on the counsel's activities prior to taking on the party's representation. That, however, is precisely the situation Mr. Griesbach has brought upon himself. As Netflix detailed in its opening brief, docket 206, Mr. Griesbach was obsessed with the Stephen Avery case for more than 15 years before plaintiff Andrew Colborn ever retained him as a counsel. First during his time as an assistant district attorney of Manitowoc County, Wisconsin, and then as the author of two books, Above This Avery Case and about the documentary series of The Heart of This Matter, Making a Murder. Thus, the court recognizes the hearing on May 25th. Netflix is not trying to turn Mr. Griesbach into a fact witness. Rather, Mr. Griesbach simply is a fact witness. Despite this, Mr. Griesbach has, to date, refused to produce even a single document responsive to the subpoena, and has raised various arguments against compelled disclosure, of all which, save one, the court rejected on the May 25th hearing on Netflix motion, the issue on which the court reserved judgment and whether Mr. Griesbach is protected from compelled disclosure of Wisconsin reporter privilege, Wisconsin Statute 88514. The court requests a supplementary briefing on the issue, which Netflix now provides. Netflix recognizes the significance of the importance of the reporter's privilege and does not make arguments against his application lightly. Netflix concedes that Mr. Griesbach remained an author rather than a legal advocate. He might have found some refuge in that statute, but he did not. As detailed below in the Netflix reply brief in support of the motion, document 221, Mr. Griesbach waived any protection he may have once have under reported privilege for two independent reasons. First, Mr. Griesbach failed to assert the protection of the privilege in his written objections to the subpoena. On this basis alone, he waived his privilege as a procedural matter. Second, by becoming counsel of record of Mr. Colborn, who featured prominently in Mr. Griesbach's books, and by using information he gathered for his books to litigate Mr. Colborn's claims against Netflix, Mr. Griesbach surrendered any claim of the journalist and waived the privilege of substantive matter. Stated differently, by using materials he gathered as an author as a sword in the proceeding, for which he is counsel of record, he can no longer hide behind the shield of statute's protections might otherwise provide. On other or both of these bases, the court should compel Mr. Griesbach to produce documents responsive to the subpoena. Footnote. Further, whatever the court decides on this issue of privilege, Netflix maintains that at least some of the documents responsive to the subpoena are subject to compelled disclosure because they were not obtained or prepared by Mr. Griesbach in a newsperson's capacity of gathering, receiving, preparing news of information, potential dissemination of the public. These include documents responsive to request numbers 7 and 11 in the subpoena. Mr. Griesbach waived any protection the Wisconsin reporter privilege may afford him. By failing to object to the subpoena on the basis of the reporter's privilege, Mr. Griesbach waived any claim of privilege he may have had. As a threshold matter, Mr. Griesbach's characterization of these documents as journalistic materials under Wisconsin statute came too late. He thus waived any protection the Wisconsin statute may have afforded him by failing to assert the privilege in his written objections to the subpoena. As the Seventh Circuit has made clear, Rule 45 requires that objecting party to raise objection before the earlier of the time specified for compliance of 14 days after the subpoena is served, so the discovery does not become a game. City of Milwaukee versus Ott, a couple of other cases they cited. 2006 rejections for 19th after service third-party subpoena deemed waived because Rule 45's 14-day time limit is strictly construed, and the failure to timely file an objection will result in a waiver of the right to object in force of the subpoena. Emphasis added. Appleton Papers Incorporated versus George A. Whitting Paper Company. Blah, 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 blah. Netflix served the subpoena on Michael Griesbach on February 10th, 2022. See second, that's for Alita Walker, and Exhibit 9, thereby obligating Mr. Griesbach to assert all objections to the subpoena by February 24th. The counsel for Mr. Griesbach served on Netflix objections to the subpoena on February 24th, but failed to assert any privilege, the reporter's privilege, or otherwise omitting any mention of the privilege, including the reporter's privilege. As Mr. Griesbach acknowledged, his counsel first asserted the privilege 2 weeks later at a March 11th meet in Confer, 29 days after Netflix served a subpoena on Mr. Griesbach, 15 days after the service of Mr. Griesbach's written objections. On this basis alone, Mr. Griesbach should be ordered to comply with the subpoena. Even if Mr. Griesbach had timely raised the reporter's privilege, he waived the protections of privilege when he took on the representation of Mr. Colborn. As Netflix argued at length in his reply brief, Mr. Griesbach waived the privilege in a separate, independent way by morphing from an alleged journalist into a legal advocate when he became counsel of the record for Mr. Colborn, and began using and sharing his journalistic work product and pursue a damage award against Netflix of more than $10 million. Second, Walker, Exhibit 10, PI's response to Chrome's first interrogatories. Simon versus Northwestern University dealt with nearly identical situation and thus directly on point. Netflix discussed that case at length in the replies brief and will not rehash its discussion here except that addressed Mr. Griesbach 2 arguments from May 25th hearing, both of which lack merit. Mr. Griesbach first argued that Simon is distinguishable on the facts. Those arguments suggest a fundamental misunderstanding of that case. The facts of Simon are eerily similar to those here. Andrew Hale created a work of nonfiction, a film, rather than a book about the plaintiff, a man named Alstory Simon. Mr. Hale's work of nonfiction was supported of Mr. Simon and questioned whether accusations of misconduct against him were accurate. Then Mr. Hale became Mr. Simon's attorney. As the court and Simon concluded, Mr. Hale waived the reporter privilege by joining the plaintiff's legal team. Just the same, Mr. Griesbach created a work of nonfiction about Mr. Colborn, the plaintiff here, which was supported of Mr. Colborn and which questioned whether accusations against him were accurate. And then Mr. Griesbach became Mr. Colborn's attorney, just as Simon court concluded. So too should this court conclude that, thus his actions, Mr. Griesbach placed himself beyond the bounds of protection under reporter's privilege. Second, Mr. Griesbach argued that the court should distinguish the Simon case as it interpreted the Illinois reporter's privilege and Wisconsin privilege as different, pointing specifically to Wisconsin Statute 88514, which states disclosure of another person and dissemination of the public of news, information, or the identity of a source by a news person does not constitute a waiver of the protection from compelled disclosure. As discussed in the hearing, the death of the case of Wisconsin, relatively new reports privilege and subsequent research has revealed a dearth of legislative history as well, but both common sense and case law from our jurisdictions reveal that falsity of Mr. Griesbach's position and confirm that whether he might have safely disclosed a journalist without waiving the privilege, he waived the privilege when he assumed the role of counsel for Mr. Colborn in this action. And undersigned explained on May 25th, a provision typical of the many state reporters' privilege laws and reflects the fact that journalists are in the business of not just gathering news, but also publishing news, and publishing some of what they gather does not waive the privilege for what they hold back. If it did, the privilege would be pointless because no journalist gathers information only to look at it all up and keep it secret. As the Simon Court explained, the report gathers information from her sources for very purposes of disclosing the information. Thus, the reporter obviously cannot waive her privilege as to the undisclosed source information by sharing other portions of the gathered source information with the public. Thus, to find the journalist waived his privilege simply because he revealed some of his sources would defeat the express purpose of this legislation. Publication of the article does not constitute a waiver of the report's privilege to refuse or disclose information obtained in the court of pursuing his professional activities, even if the source of the article identified, United States versus Cuthbertson. Holding the privilege extends unpublished materials in the possession of CBS, Saxon, Arc Gazette Company. Neither can we agree with the appellate's content of the appellate. By the volunteer disclosure of the identity of our sources, waive whether privilege she had. Contrary to the state's contention, publication of the part of the information gathered does not waive the privilege as to all information gathered in the same subject matter, because it would chill a free flow of information to the public. Mark citation admitted. Waiver of newsman applies only in the statements made by the informer, which are actually published and publicly disclosed, and not other statements made by the informer of the newspaper. Separately, the Silverstein case, which cited in Simon, also sheds light on what the phrase disclosure of another person means. Specifically, Silverstein addressed whether a journalist had waived the protection of the reporter's privilege by disclosing some of the sources to the prosecutor in a criminal matter. As the court concluded, there was no indication that the journalist had personally motivated the action of the prosecutor in investigating the matter on hand. Regular contracts with the attorney were clearly the scope of his role as a newspaper reporter, and any information he may have given to the attorney concerning his news gathering efforts, which was made public in his articles, does not cause him to forfeit his privilege as a reporter. As the court made clear, however, had the journalist abandoned the role of newspaper reporter and assumed the duties of an investigator, then arguably he waived his reporter privilege. In other words, sometimes journalists need to tell their sources certain unpublished information to provide context for the questions they pose and the information they seek. And those sorts of disclosures do not constitute a waiver of privilege either, as both the Wisconsin statute and other courts around the country recognize. For example, the New Jersey Supreme Court explained that the state's reporter privilege could be waived, but that is, the disclosure of information by a newsperson outside of the news gathering and news reporting process. That constitutes a waiver of privilege. Emphasis added. Courts have also held that in one thing to disclose information, purpose of news gathering, and quite another to disclose information pursuant to the agenda, and the later constitutes waiver, even though the former does not. For example, a federal court noted that the interest of fairness in journalist authors should be permitted in disclosure information in advance interest of one litigant, and revoke the journalist's privilege and prevent discovery of the same information by another litigant. Similarly, the Second Circuit Court of Appeals has held that those who do not retain independence as what they will publish but are subservient of the objections of others would have to stake in what they publish have either a weaker privilege or none at all. Another footnote, journalists in the action admitted they was biased in favor of petitioner, and it can be assumed that wish to be assistants to petitioner's counsel, it would be unfair and improper to allow him to invoke a journalist's privilege with respect to the same material now respondent's counsel wants to see. Also, Wheeler v. Colborn, applicant cannot choose to disclose to others in 1986 with no request of confidentiality under circumstances which did not involve any news gathering function. That Fullwood was her source for the classified information and then chose in 1991 as a witness in judicial proceeding not to take this same disclosure. Although the statute provides the publication or broadcasting information does not waive the privilege set to the filing document of public records lawsuit, different matter. We emphasize that our decision today extends protection only to the journalist, news gathering, and dissemination activities within the journalist's professional capacity. Nevada's News Shield statute provides no protection for information gathering in other capacities. We further recognize, although the News Shield statute provides absolute privilege to reporters engaged in the news gathering process, there are situations which the News Shield statute might have to yield so that the justice may be served. And this Second Circuit articulated broader discussion about the evidentiary privileges, whether fairness requires disclosure and best decided on the case-by-case basis, and depends primarily on the specific context in which the privilege is asserted. For example, we look to see whether the privileges holder took affirmative steps and inject privileged materials into litigation. Thus, for example, if the journalist is investigating a news tip, what amounts to a rumor, she typically has to share the tip with her sources in order to assess the validity. The journalist may untimely decide the tip is baseless or never publish anything about it, but the fact that she shared it with a discrete individuals as part of the investigation efforts does not itself waive the privilege, such as she would be compelled to testify about the tip. Similarly, a journalist attempting to determine if the leaked document is authentic may need to share the document or information about the other source before deciding whether or not to report on it. In short, presumable disclosure of unpublished information in its context, a journalist's news gathering and published activities does not waive the privilege. And disclosure to another language in Wisconsin simply makes that clear. But that's not what we're talking about here. Netflix is not claiming Mr. Griesbach waived his reporter privilege by giving unpublished information to the publisher or his agent or even his sources in the course of writing and publishing his books. Rather, it is arguing that he is a journalist turned counsel, just like the filmmaker in Simon, that, just like the filmmaker, he waived his privilege when he stopped using his journalistic work product to inform, enlighten the public and start using a personal motive. Mr. Colborn's legal strategy in his attempt to win a multi-million-dollar lawsuit against Netflix, like the filmmaker in Simon, Mr. Griesbach appears not to recognize the consequences of acting as a reporter and a lawyer on the same matter. Mr. Griesbach shared all the information by gathering during his research and writing of his books. In addition, the sources of journalists sometimes need to be shared unpublished information with their editors, publishers, lawyers, among others. But it continues when he joined Mr. Colborn's legal team, and thus he placed all the risk of the source information that may have been shielded by the reporter's privilege. Moreover, whatever Mr. Griesbach might have safely shared as a journalist, he clearly acted outside the scope of a reporter when he became an attorney on plaintiff's legal team. And after serving as plaintiff's counsel for more than 2 years, the attorney cannot artificially divest himself of the status in order to take advantage of the reporter's privilege. When Mr. Griesbach filed an appearance in the plaintiff's case, he abandoned the role of reporter and transitioned to the role of legal advocate. Assertion of the reporter's privilege in the context is well beyond the scope of the statute. This all makes perfect sense in the light of the policies and admitting the journalist's privileges around the country. The subpoenas should not distract the journalists from their important constitutionally protected work of gathering, reporting news, nor burden journalists of their newsrooms with unnecessary expense, nor threaten journalists' independence and reputations for neutrality by positioning them as an extension of the law enforcement or as advocates for the privileged litigants. Certainly, we do not hold that the state federal authorities are free to annex the news media investigate arm of the government. Subpoenas to attorneys such as Michael Griesbach or Mr. Griesbach simply do not threaten these policies. Compelling Mr. Griesbach compliance with the subpoena cannot inhibit his news gathering activities or undermine future claims of journalistic objectivity in any way material different than when he voluntarily accepted, even invited, when he nearly 4 years ago, he voluntarily abandoned his semblance of neutrality and agreed to sue Netflix on Mr. Colborn's behalf. Similarly, counsel of record Mr. Griesbach quickly remains deeply involved in the lawsuit, and compelling his compliance with the subpoena simply cannot burden or distract him in any manner materially greater than the burden he already faces as counsel of record. Simply stated, the policy considerates behind the privilege no longer applied to Mr. Griesbach, and his basis as well. Mr. Griesbach should be compelled to comply with the subpoena. The court need not and should not address the four-factor test for overcoming the privilege. Even in the absence of the waiver pursuant to Wisconsin reporter privilege, a court may order discovery of journalists' news gathering materials if four conditions are met. The news information or identity of the source is highly relevant to the proceeding. The news information and identity of the source is necessary to maintain a party's defense or the proof of issue material for the proceeding. The news information or identity of the source is not obtainable from any alternative source for the proceeding. There is overriding public interest in disclosure of the news information or identity of the source. On May 25th hearing, counsel for Mr. Griesbach repeatedly argued that the Netflix had failed to satisfy these four conditions, and thus the motion to compel should be denied. This argument raised interesting questions about whether Netflix could meet those conditions, but ignored Netflix has never actually tried to do so. Indeed, Netflix has been deliberately silent on whether, in the unlikely event the court deems the privilege unwaived, the privilege has been overcome. Netflix has been silent on this issue, not only because that case for waiver is so strong that the argument on the four conditions is superfluous, and also because it believes that strongly the importance of privilege does not wish to chip away at its protections in a way that could harm bona fide news persons who do important work in this state. Moreover, in this case, given an unusual fact pattern as hardly the best vehicle for analyzing the contours of the four-factor test, for all these reasons, and also because any written order on the four-factor test would likely carry disproportionate weight given the lack of published decisions interpreting the statute, Netflix discouraged the court from issuing a dicta on whether the test could be satisfied. That said, without attempting to show that it satisfied all four factors, Netflix directs the court's attention to the fourth and final one, which requires examination of the public interest, and the case law discussed above this makes clear. Courts take an unfavorable view toward journalists who try to put a thumb on the scales of justice by using their privilege as both a shield and a sword, offering information to help one party while withholding information from another. As the California court said, providing selective access to litigants of news-gathering material is simply not fair, and as Nevada court made clear, there are certain circumstances where justice requires that journalists be compelled to provide discovery of their news-gathering material. Here we have more than a thumb on a scale, more mere selective and strategic disclosure by journalists. Instead, we have a long-time lawyer and two-time author who has completely abandoned any journalistic principles of neutrality and objectively has once held in pursuit of the multi-million-dollar damage award that he hopes to obtain through his journalistic work product that mistakenly believes to somehow still... This is funny. For 15 years, Mr. Colborn retained his counsel, Mr. Griesbach, obsessed over the Avery saga, first as a prosecutor and then as the author of 2 books on the matter. Whether Mr. Griesbach, a fact witness in the case, who appears in Making a Murder itself, should have accepted representation of Mr. Colborn in a question for another day, but the fact remains that once Mr. Griesbach became counsel of Mr. Colborn, he subsequently drew his lengthy history with the facts at issue in the litigation to benefit Mr. Colborn. Indeed, even asking the fact-checker of his book, Mr. Schuler, to edit the early draft of Mr. Colborn's first complaint in the lawsuit, second Walker Diesel, Exhibit 11, Colborn, prohibiting Netflix from receiving access to the same information that Mr. Griesbach accumulated prior to his representation of Mr. Colborn, places Netflix at a distinct disadvantage that exist in a direct consequence of Mr. Griesbach's actions to this matter. Mutual knowledge of all the relevant facts gathered by both parties is essential to proper litigation. Conclusion. For the foregoing reasons, for those that stated in Netflix's earlier briefing in this matter, Netflix respectfully requests that the court find Mr. Griesbach waived any privilege to which he may have once entitled under Wisconsin reporter privilege, and Mr. Griesbach be compelled to comply with the subpoena. Dated this day, June 8th, 2022. This is document 1 of document 2 that was filed today. I'm going to get everything ready, and I'll be back in a little bit later.